We'll probably allow about 1 minute after 1 or 2 minutes, and then I'll drop a message on the chat box that we're about to start. Thanks.
It's already broadcasting now. Thank you.
do? You do?
Yes.
Good afternoon to everyone. I would like to welcome you to our webinar this afternoon, hosted by the Chartered Institute of Arbitrators of Qatar in collaboration with Ashghal on the value of alternative dispute resolution approaches over litigation. My name is Katerina Stathi. I am a fellow of the Chartered Institute of Arbitrators since 2016 and a legal counsel specializing in commercial and corporate law, mainly in the pharmaceutical industry. Our speakers this afternoon are Mrs. Paula Boast, Head of Construction Engineering and Projects for the Middle East region at Charles Russell Speechlys, Mr. Ahmad Ali Ansanari, Technical Office Manager, Public Works Authority of Qatar, Ashghal. Mr. Al-Ansari is also the chairman of the Chartered Institute of Arbitrators here in Qatar, and Mr. Tom Kapapa, Head of Operations Qatar at HKA. Just a little bit of housekeeping before we start. We will all be muted by the administrator in order to ensure the smooth running of the webinar. And during the process, you will be able to click on the box Q&A at the end of at the bottom of your panel in order to type any questions which will be addressed to the speakers. So after the three speakers finish their presentations, we will have the time to hopefully address all or most of your questions. I would like to give the floor to Mrs. Paula Boast, who will be our first speaker for this afternoon. Paula.
Thank you, Katerina, and welcome everyone to the session. I'm going to ask Narul to guide me through my slides today, if that's at all possible, so we can make a start. I'm going to talk to you a little bit about how the value of ADR, or alternative dispute resolution, is approached in terms of value against litigation, particularly as it pertains to construction disputes today. So, Narul, if I could have the next slide, please. So just by way of introduction, and I mean, this is really basic stuff for many of you out there who are involved in the construction sector, but the three pillars of construction projects essentially come down to time and program, money price, and quality of what we are building. So there are set pieces of objectives, which are essentially that we need to finish on time, we need to finish within budget, and that we need to finish with an asset which is actually usable, and wherever possible, that it is fit for the purpose that it's been designed. Now, as against those objectives, we also have an overriding objective as lawyers who work for contractors or supply chain or employers, and that is that we also want to finish our projects without any claims and without any disputes. In a lovely world, that's what we're all aiming for. Next slide, please. So in terms of project risks and the common claims and disputes that we see, I thought it'd be helpful to touch on those before we delve into the ADR litigation arena. And essentially, the list on the left will come as no surprise to many of you in the industry. We see changes in scopes of work, variations, delays, cash flow issues, payments, whether they are delayed payments or they are non-payments, two very different things. Design defects are very prevalent, and of course we have the world that sits around suspension and termination of our contracts on projects generally. But essentially all of those things, regardless of what the problem may be on your project or in relation to a dispute, the chances are it has one of the repercussions or more than one of the repercussions on the right-hand side. It costs you more time, and or it costs you more money, and or it results in a poor quality constructed projects, which are ultimately the things we're trying to avoid. So in terms of resolving those disputes, then we have the traditional auspices of litigation in a courtroom, in the old-fashioned way, if you like. And then we have alternative dispute resolution methods, which are more and more prevalently used throughout the Middle East region, and in particular the Qatar market right now. Next slide. So in terms of that litigation approach, as I say, this is what we view as being traditional, and because of that, it is a very formal process. And some countries are lucky enough to have a formal construction or technical court, but unfortunately across the Middle East, we don't have those yet, but we will start to see those. And there is an emergence, for example, of a technology and construction type court coming out of the DIFC right now. I've given you a little link there for any of you who may see the slides later if you're interested in how the TCC works and the origins of that out of the United Kingdom, where it was very much a model back at the beginning of the 2000s, and now 20 years on, it is probably one of the most important courts in the UK judicial system. It's very specialised, and they are used to dealing with very technical disputes that we see within the construction sector. So even if you get into those litigation proceedings in the Middle East or in the Qatar forum, what you can expect are very formal public legal proceedings. They are a matter of record, essentially, and they are not private. And this is one of the big things that is always weighed up when there's a discussion then about ADR. The other things that you can expect from that process would be full disclosure of documents. You will have to prepare witness statements. There will be expert reviews and reports, but very often they can be imposed upon you so that you don't have any choice in who that expert may be. You'll probably see multiple court hearings before a judge, multiple adjournments of court hearings, depending upon applications to be made or the conduct of the other side or the other party. So all in all, it's a really lengthy process, and it's not helped by the fact that in litigation, tactically, we see some parties who use and sometimes abuse the rules, whether it's by way of making additional applications or generally trying to make the litigation process more difficult for people on the other side. And that's a detriment of litigation. It has to be said. The other issue that we then face is when you reach the end of your litigation process, whether you are the winner or the loser, there will be enforcement issues that sit around that judgment. And there's never any guarantee that the party that you may have started proceedings against has the means to actually pay you when the litigation process itself is finished. So from a time and expense perspective, it can be lengthy and expensive. And if you do not manage to recover when you try to enforce your judgment, it may well be that actually you are left out of pocket at the end of the day. So it's litigation proceedings are not to be undertaken lightly, and they require a very measured approach on a case-by-case basis. Next slide, please. So in terms of ADR, it's a little bit of extra background for you, but it was really born out of a bit of a surge in what we would call sector litigation in the 1990s. The construction industry has always been heralded as a difficult, litigious, dispute-ridden sector by comparison to other business sectors. And in the 90s, that was very prevalent because there had been a recession. The industry was very, very much impacted. And there were a lot of litigations that were derived from those financial circumstances. By that point in time, court lists, not just in the Middle East, but all over the world, had become quite long for construction cases. In some countries, it was taken up to 2 years to move through that legal system. Countries were starting to understand within their own judiciaries that litigation was becoming too expensive. It's too costly and it takes too long. And then there were concerns about those proceedings being conducted in the public domain. A lot of entities were becoming more aware of their brand, their commercial sensitivity, their intellectual property in the market by virtue of being specialist contracting entities, for example. So there was this kind of a push towards requiring more privacy around the disputes that were being played out. There was also no flexibility really in the procedure or the timetabling. Once you're within the court system, it's really up to the court as to when you appear, when you make your submissions, when you have your hearings. And that lack of flexibility doesn't always necessarily work very well for the parties either. And then at the end of the day, there was just no real account of the actual commercial needs of the parties. No one ever sat back and said, this is going to ruin a business relationship. Litigation is not a procedure that lends itself very well to a continuation of relationships. And at the end of the day, business to business, that really is the most important aspect, particularly when you're in markets like Qatar, where on the ground, we feel more like a village. Sometimes we know everyone, we work with everyone, we have those connections. Going through litigation processes, therefore, makes that business relationship continuity very, very difficult. Next slide, please. So then in terms of ADR in the Middle East, it has emerged in a number of ways. Through contract drafting, we already see staged approaches within the dispute resolution provisions. And I know certainly that Ahmed is going to take you through a little bit more of that and how that works in the Ashghal Public Works Authority world. And there are tiers to how you get into it. So even in the most hardened dispute resolution contract clauses, we tend to see a blend of an ADR and a litigation approach. Okay, so there will be a number of steps to take. You will start probably with some amicable settlement for a period of time. You then may move into a regime such as mediation or adjudication, or expert determination is another realm that we see as well, before you either finally end up in an arbitration or in a litigation at the end of the day for what will be a final determination in relation to your dispute. So ADR is something that begins very early on, or can begin very early on in the dispute procedure itself. So parties will already play a role in that, and they will do some ADR. And it's really only very hardened, difficult and complex cases which cannot be resolved for whatever reason that will end up within an arbitration or litigation regime. But there's just little pointers there for you on how they work essentially in their own worlds. But the big thing that you will see there is that they are all private. So there is a real trend around ADR maintaining privacy between the parties, and that is incredibly important from a commercial perspective. But for mediation, more prevalent in region, we do have sets of mediation rules out of the DIFC, for example. Bahrain Chamber of Dispute Resolution has also had a set for nearly 10 years now. It's very informal, and the idea is that you reach an agreed settlement between the parties. It's not a judgment or an award. It only takes a few days. So people like it because of the very informal nature of the process. Adjudication was born in the UK, very much linked to that idea back in the 90s that court cases were too long, too expensive, and therefore it imposes something around a 42-day procedure if you use a model that is similar to the UK model. And it's short, it's expert-led, and it's designed to be a sharp, quick, inexpensive route to getting an adjudicator's decision. So again, it's not a judgment, it's a decision. The parties will sign an agreement to ensure that that decision is upheld and can be upheld by the courts. Similar regime to that would be expert determination, works in a very, very similar kind of way. Arbitration then is the mainstay of ADR. Many people don't realize that arbitration is actually a form of alternative dispute resolution. They bracket it into the same pocket as litigation, but it is very different. And the great news about arbitration is it's long used and trusted in the Middle East. We've all had our particular models and arbitration processes in a variety of Middle East countries. Oman were the first to start back in the 1960s, and that has now prevaricated through the whole of the region. And of course, Qatar has its own arbitration procedural laws. You get a choice of rules, you get a choice of arbitrators, and you get a choice of experts. It's all about choice. You get flexibility over timetabling and procedure. And then you end up with an enforceable award at the end of the day, courtesy of the sign up within region to what is known as the New York Convention, which helps ensure that you get a return on your investment into the arbitration process. Next slide, please. Joseph Grimbaum is an international mediator, and he likes to, if you see him on LinkedIn, he's a very, very prevalent man. And he says that an ounce of mediation is worth a pound of arbitration and a ton of litigation. I don't necessarily disagree with Joseph. Next slide. But before we all run off and we use ADR, I have to pull you back a little bit gently and just say that it does work and there is value. And that is played out by the fact that we have these multi-tier type dispute resolution contract clauses in the market. And it has to be weighed up against the traditional litigation basis. And we do that case by case, because at the end of the day, disputes still have to fit within the law. We do still have to stick to the rules and the procedures and the law that sits around the terms of the contract itself, okay? So generally, in a nutshell, when you're considering litigation as against ADR, your resolution process and the method that you adopt will boil down really to a couple of very key points. What are the provisions in your contract? So before you even get into a dispute, maybe you're managing a very difficult claim, take yourself away from the claim clause and have a look at where your claim will go within the dispute procedure if you continue down that road, and understand how those provisions are going to work, what you need to do. Your timeframes and your timescales within those are very, very important. Think about the timescale of the urgency of the action. Is this something that requires a quick, sharp shock? Or are we talking about something that's slightly more pertinent, such as a termination, for example, where you may have no choice under your contract but to go off to the Qatari court and obtain a court order to be able to release you from your contractual obligations? So we do have to think about urgency in terms of where you are at this point in time and the steps that you want to take. How much budget do you have to resolve your dispute? Very, very important question. And it really can sometimes commercially boil down to what you can afford to do. Think about whether you need a simple mediation process. Does the value of the claim or dispute warrant you spending lots of money in either a litigation or an arbitration at the end of the day? And think about how you can reach some type of resolution much more quickly and much more cost efficiently as well. Okay, I rarely see clients who have set aside significant budgets for disputes in major projects. It's just one of those things that's not done at the outset of projects, and it tends to hinder parties when they do get into a major dispute at the end. So if you don't have much budget, be realistic about what you can do and what's achievable. Think about the project value of privacy around it. Will you be concerned if your case has to end up in the Qatari courts in the litigation process? Would you prefer something more private? And that, again, commercial consideration to be talked about around the table and at board level before you make any major decisions about proceeding. And then think about how easy it is to enforce a court judgment if you were to go through the litigation process, the mediation settlement agreement if you go through mediation and you reach a settlement, the adjudication decision that is reached by any adjudicator, or indeed your arbitration award that may be reached by any tribunal. So ADR is great, and there is a huge amount of value in it. And I think actually, for the most part in Qatari contracts, we already involve ourselves in an ADR process to some extent. It's really only at that final hurdle for very serious complex cases that we are then forced to make a decision as between litigation and arbitration at the end of the day. I think that's all from me. Katarina, back to you.
Thank you, Paula, very much for this very interesting presentation. Paula has approached our topic today from the construction industry perspective, obviously, which is her area of expertise. We will now move on to Ahmed, who will approach and give us the public sector perspective.
Thanks, Catherine.
Ahmad, the floor to you.
Very much. And thanks to Paula for the very interesting talk. Well, I'm going to cover the settlement of dispute under the Public Works Suite of Contract, the new one, which was issued in 2018. Now, this is the famous clause, clause number 19, covers claims and settlement of dispute. Obviously, claims have got 3 sub-clauses, but obviously the emphasis of my talk going to be on the settlement of disputes. We have 5 different forms of dispute settlements here: engineer determination, amicable settlement, express decision, reference to court, and finally arbitration. Next one, please. Now, clause 19.4, engineer's determination, as you may know, similar to FIDIC, this is a standard practice we do with Ashghal as well. Whenever a dispute is emerged, a notice of dissatisfaction is issued either by either party, whether it's the client or the contractor. And obviously, the engineer will have 35 days to issue his to study the dispute and also issue his determination. Now, in case he fails to issue its determination within the 35 days, then both parties have the right within 14 days to issue an notice to each other to refer the dispute to the next stage, which is amicable settlement. Next, please. Now, under the amicable settlement, the individuals who are nominated by both parties have to be named at the very early stage of signing the contract. So the time of signing the contract, the representatives of parties are named, and those 2 representatives have, within 21 days after giving the notice, to refer this to amicable settlement to resolve it. Now, again, in case both of them fail to come to an amicable settlement, then obviously the dispute can be escalated and moved into the next step, which is the expert decision. Next one, please. Now, the expert decision, the way I look at it, is equivalent to adjudication, to be honest, okay? And, within 28 days, this case is referred to the expert for his decision. And basically, again, the expert has to, pass his decision within 28 days. Now, again, if he fails to pass his decision or make his decision within 28 days, then both parties have the right also to go to court or arbitration. Now, I'm going to elaborate further on that. Let's go talk about the court first. Next one, please. Now, reference to court, obviously, if all the means of ADRs are exhausted and the dispute is either rejected by either party or for some reasons the engineer or the expert failed to pass their determination and decisions, then either party will have the right to refer the case to court, the dispute. But the real question here is, when you go to court, is it practical to refer every single dispute to court? Yeah, or you'd rather to wait until the very end when you end up with perhaps many disputes and you go to court? This is a big question. And this rule also applies throughout to the different ADRs we have in place. How many times you have to seek, for instance, engineer determination, how many times you have to refer any disputes to expert, and what kind of expert you are talking about here. Is it a technical dispute? Is it commercial? Is it financial? So it's really a great, very complex kind of process. Or would you rather to put many disputes together and refer them once to an expert, for instance, in a particular field, rather than going to expert every time? So that's proven to be, to a certain degree, an expensive process. So this is something that we are currently reviewing and trying to find out better ways and better means of being so practical by adopting ADRs into our contracts. Now, if both parties, can you go to the next step, please? Next slide. Now, if both parties build the understanding, okay, to go for arbitration in lieu of court, it is very much possible. that both parties can, agree on mutual basis to use arbitration rather than going to court. But we do have certain obstacles and hurdles to fully satisfy that, which I'm going to talk about in the next slide. Anyway, however, now, if a case is referred to arbitration, for instance, now, as per our condition of contract, it has to follow the rules and regulations of Qatar International Center for Conciliation and Arbitration, which is part of the Qatar Chamber of Commerce. Okay, and the seat shall be Doha, and all hearings shall be held in Qatar unless otherwise agreed by the parties, because some parties may ask for to hold the hearing elsewhere, like UK or France or whatever. And then any such arbitration shall be subject to the law. And what I mean by the law is the law of Qatar. The law under our contracts is defined as being the national or public legislations, decrees, ordinances, rules, and regulations relevant to works or the project which are in force in the state of Qatar. All right. So basically, the applicable law to any arbitration held here in Qatar has to be the law of Qatar. And then the language we put in our condition, the language which is going to be used in any arbitration is going to be the English language. But again, very recently, I must say that we issued those conditions 4 years ago. But recently, there was an immediate decree to use Arabic language in all government departments, for instance. So we are looking into that, how we could possibly satisfy that requirement with many, foreign companies operating and working here in Qatar, which might be a problem. But again, translation is not a cheap process here in Qatar as well. So we're looking into that. We try to come up with a moderate kind of solution to balance things up and live with that requirement. And when it comes to arbitration, again, we give the options either to appoint a sole arbitrator or appoint an arbitral panel. And one thing important also here that any arbitration may commence prior to or after completion of the contract. It's not very common here, to be honest, to start any arbitration case before the completion of the works. And I have noticed in some of the contracts here in Qatar, I don't want to mention the government agency, that they inserted a very difficult clause that no arbitration can start until the very end and completion of the works, which made things too difficult for contractors, and perhaps they considered that as a very high risk, which I'm sure they consider the premium, and they build that the cost that risk into their prices. Then the parties agree that all interim or final decisions or awards shall be binding on the parties and given effect and implemented forward by them. Now, this is also something very important. I know some parties will not be happy with any kind of decision or award issued by the arbitral panel, and we seek other alternative routes to file appeal against that. But it's very important that both parties do fully adhere to any award issued by arbitral panels. And then, obviously, if that is achieved, both parties obviously, shall not refer any of arbitral cases to Qatar court thereafter. Contracts and works continue during proceedings and hearing. This is in case if any arbitration proceedings or hearings started before the completion of the works, it should not affect the performance of and the delivery of the project works, basically. Now, this is the most difficult bit about going for arbitration clause in administrative contracts. Obviously, what I mean by administrative contracts, I think contract with the government agency here. Now, this is something not very popular, to be honest, and it's not really practiced to satisfactory level here, with exception to some few contracts which require certain technologies and niche owned by, you know, a cartel or a few companies may own, like power stations, for instance, oil and gas. There are only a few companies who are really expert in certain fields, and they insist on inserting arbitration rather than court in their any contract they may sign with the state of Qatar. But with our projects, public works, for instance, not considered to be of any high tech, for instance. There are many local companies can work in that, and also many international firms can work in that. So the government is not really feel obliged or motivated to go for arbitration. Although we are the insiders, we prefer to go for arbitration because it's much more faster and cost effective as well. But unfortunately, if we decide to go for any arbitration in lieu of litigation, then we have to seek the approval of the Prime Minister. And it's again very lengthy. So you could imagine it during tender stage. We put court, and then once the job is awarded to somebody based on some, for example, discussions or mutual understanding, we come up with some sort of arrangement to use arbitration, but we have to put that forward to the Prime Minister's office. It could take a month, it could take 2 months, which may, you know, influence the commencement date of any works. And we are, you know, definitely working so hard to replace court with arbitration as a final ADR method. Now, the most important thing, how much the market or the industry, let me say, aware of the benefits they are going to get of arbitration. Believe it or not, many contractors now, if you talk to them, you say, can we have arbitration or ADR rather than court? And they say, no, we prefer to go to court. So probably it's not mature enough for many people here to understand or appreciate, you know, the advantage that they're going to gain by having arbitration instead of litigation. Now, thank you very much. I'll be happy to take any questions afterwards.
Thank you. Thank you very much for your presentation and the very interesting insights in the public sector perspective. I would now like to move on to Tom Kapapa, who will give us the expert perspective to our topic this afternoon, who, as we all know, play a very, very important role in the ADR procedures. Tom.
Thank you, Katerina, and thank you, Abant and Paula. So unfortunately, I don't have any slides, and that's intentionally, because as experts, we tend to fill in the gaps, I suppose, with issues of litigation or ADR. And really, the talk of ADR and litigation in construction is purely because construction is quite complex. It's usually unique. So you can do the same project in different locations and the results are completely different. The people are different. And this is why the topic of litigation and ADR are very, very important. So again, without repeating what Paula and Ahmad has just said, is construction is issues of litigation and ADR is because there's so much disagreements in construction. And these disagreements can be very complex technical issues, engineering issues. And these technical complex engineering issues lead into delayed delivery schedules, which of course result in additional expense with regards to prolongation or disruption matters. And of course, the complex engineering issues lead into valuation of variations, disagreements, and also you end up having damages issues. For instance, you may have delayed damages from the employer or actually loss of revenue if you're a developer. So the issue of litigation and/or ADR in construction are obviously very important topics for that very reason. So as experts, of course, construction experts, we are part of this process, and really why I'm involved in this talk is with experts, we are there to help the parties, I suppose, reach a common ground. But the key issue here with experts is the underlying principles experts have is we have to act independently. So with matters of litigation or using ADR, the expert's role does not really change because at the end of the day, the expert has to act independently, and the expert has to be able to have the experience or be with the experience required to deal with the matter that is in dispute. So experts are very important with regards to the process of arbitration, expert determination, and all that. So with litigation, of course, the role of an expert is quite well defined, based on procedural rules. And obviously the courts themselves, or as I said, the laws governing the dispute. So those will be specific in the sense of how the experts will actually be required to give evidence, whether in writing or orally. With litigation, again, you have very limited choice as parties in a dispute with regards to the choice of the judge. And indeed, you might have a limited opportunity with regards to the choice of a neutral expert who might be appointed by the courts, particularly if you here in Qatar, the courts have got a list of their own experts who might be from accounting background. Some of them may be engineering. But as I said earlier, construction is quite complex. It's very difficult to actually narrow disputes to just limited to accounting or whether it's an engineering issue. And that's because construction, a technical issue may lead into matters of delay. It may lead into matters of actually dealing with the variation. It might lead into matters of defects. So it's a very complex industry, in the sense that if you go to litigation, you're very limited and no choice on what experts you can use for that process. Paula mentioned earlier, obviously the UK have set up the technical and construction courts, and this was mainly just brought in to ensure that, I suppose, the experience and the judge, the judicial system was very specific to construction. To ensure that the process was appreciated. And obviously it's a very important court now. With ADR, of course, I believe parties in dispute or in an agreement have got an opportunity to actually manage the whole process, and of course an opportunity to ensure that the process or the dispute itself is heard or delivered by people who they believe are experts in the field of the dispute itself. So it's very flexible. There's few rules, procedural rules. I suppose with institutional arbitrations institutional arbitrations, you will find procedural rules which are there in the sense of appointment or delivering or giving evidence for experts, but the rules are not really set, and the parties can actually agree the rules. So it's very flexible, allows parties to actually determine their destiny, if you like, and agree a flexibility that meets everyone else. And of course, in ADR processes, the expert can take different roles. It can be advising clients and actually offer expert evidence after that. So the process actually is quite flexible depending on what the clients really want from it. with arbitrators or mediators, or if it's expert determination, again, you can choose arbitrators who are experts in the fields that the dispute is on. Mediation, the same, and all this is it's important to note that because construction is very driven by experience and expertise, it's always important that you actually have the audience to deal with matters, especially in dispute. And this is why ADR is processes which are being favored to allow the process of at least reaching amicable settlement. If you look at the Ashghal process, the reason it's so staged is to try and ensure that by the time you decide if indeed you can't agree to go to arbitration, is at least you'll have narrowed down the issues in terms of what really the dispute is. And because the expert, again, because the ADRs are not specific rules, the expert can be used for all different issues. In mediation, the parties can actually get or the mediator himself can be the expert, or the parties can agree to bring in a neutral expert to try and narrow down what really the dispute is. And that also helps in the sense that the expert can bring to the party an understanding of where their strengths and weaknesses are, and particularly noting that experts are always, their duty is always to be independent and not really giving opinion to support who's paying them the money. The expert is always important that he stays independent. And even if there was no rules, most of the experts are either chartered of the Arbitration Institute of Arbitrators, or they can be chartered surveyors or chartered engineers. And these institutions have a code of conduct for people who are appointed or giving evidence as experts. And therefore they would always have to be independent, otherwise it would be against their code of conduct. So having said all that, it's clearly important that it's recognized that a case or a dispute is either won or lost depending on who the experts you bring to the fore, in terms of whether it's the tribunal setup, whether it's the expert brought in for expert determination, whether it's mediation. Again, choosing the right people with the right experience and qualification can help with regards to whether you win or lose the case. So it's always important to ensure that you understand the process itself. ADR gives you the opportunity to actually choose for yourself, whereas litigation, you're very limited in terms of choice of who actually hears your case or who's the expert for the case in terms of neutral expert appointed by the courts. So experts are key players in ADR. And in other matters, experts would be brought in early to actually to have hot tubbing, if you like, between the experts, opposing experts, and in doing so in early parts of agreeing a joint statement, if you like, the experts may actually highlight areas where there's actually common agreement and areas where disagreement is, to focus the dispute itself. So whereas in litigation, you're very limited to having that opportunity because it's all set rules and all that, whereas ADR, the parties can agree to have that sort of procedure to ensure that either matters can settle early, or actually to try and focus on what really the dispute is. So the expert will always try to ensure that the ADR process, like I say, the ADR process supports experts. And that's not to say that litigation does not have experts. The role of the expert is the same, whether in litigation or in any of the ADR processes. It's just that the ADR processes are very much without very much procedural, I suppose it's litigation, whereas the ADRs, the parties can agree the procedure that suits the matter that is being in dispute, whether it's timing, whether it's availability of experts, and all that. So ADR gives you the best benefits. So if you look at the value of ADR to litigation, clearly ADR gives parties a better comfort in the sense that you are in control of your destiny with regards to when a dispute starts. You get involved in the choice of the experts and the people and the processes that will follow, whereas the court is the procedures are set. And I think Paula mentioned earlier, with the court system, there can be a lot of applications that can delay the process and all that because of the way the court system actually works. So really that's looking at it from the point of experts, because construction is really construction expert driven. We consider ADR to be actually of value, because this is where we can actually assist clients or employers or contractors, suppliers to at least reach a point where settlement can either be agreed earlier or cases can be withdrawn by the understanding of the strengths and weaknesses of such cases. And that's really my contribution to this talk on ADR value on litigation.
Thank you, Tom. Thank you very much for this, for bringing us your insight into the complexities actually that come into play for experts, and how they have to, the important role they play in the ADR process. So now we have just a little bit more than 10 minutes left for our webinar this afternoon. I believe there is an attendee who has raised their hand. I would please ask, if possible, to type any question in the Q&A box at the bottom of your screen. I already see that we have 3 questions, which I hope we will have the time to address. The first one, I understand, is for Ahmed, because it relates to Ashghal in particular. And the question is if Ashghal contracts allow ADR. If you can please unmute, Ahmed, we cannot hear you. You are muted, Ahmed.
Can you hear me now?
Yes, we can. Thank you.
I'm sure Norel perhaps unmuted. Anyway, this is what I have just talked about. Okay, the range of ADRs, perhaps not all of it there, but of course there is the expert decision and amicable settlement. Those 2 ways are used in our contracts. But may I contribute with a general statement? Are we really, following the sequence of dispute resolution within our contract? This is the main problem. Although we say engineer determination followed by amicable settlement, then expert decision prior to going to court or arbitration, it just happened. Sometimes post engineer determination, in case it is not satisfactory to or rejected by either party. Some parties just jump straight away into court. They're not interested in going for amicable settlement or expert decision sometimes. Okay, There is nothing much we can do about that. That is to be the wish of the contractor, for instance, to go straight away to court rather than exhausting the sequence of dispute resolution process within our condition of contract. The other thing is, unfortunately, there isn't much belief in engineers' determination, actually, being paid by the employer, and obviously the impartiality might be questioned. There is this kind of culture here we have in this market. The guy asked also, who's the engineer? Now, in our contract, the engineer normally named by the president and happens to be the director of the affairs, for instance, or the manager of the department in which a project is implemented through, whether it's highway, project department, local roads, drainage, and the like. And of course, the engineer has the right to appoint a representative, to nominate or delegate his authority or some of his authority to a representative. Thank you.
Okay. Paula, the next question is for you concerning the adjudication rules. So the rules in the UK require either side to state that the dispute is confidential before it will be considered private by each side and adjudicator. Do the adjudication rules in Qatar require confidentiality without this request?
Okay, so I need to strip it back a little bit for Seth. The difference in terms of using adjudication here in Qatar and using it in the UK is that the UK has what is essentially an adjudication law for all intents and purposes. We don't have that here. So the procedure that you have to enter into is that, number one, the parties have to agree. So your adjudication mechanism or your expert determination mechanism, I use them interchangeably depending upon what you want to have, has to be embedded within your tiered stage dispute resolution clause, essentially in Qatar. And if you have provision for that, then you can proceed. And generally what you will do is that within that drafting, it should say that the proceedings will be held privately with the parties. You're quite right. Once you hit the court, there will be a question over that. But for the most part, you'll only be in the enforcement court. It's not that you will be in full-blown proceedings. There won't be a dispute over the content of the decision. It will be a dispute over the enforcement of the decision. So it's quite a different thing altogether. It's like a small issue really at the end of the process. But just taking you back to the beginning of the process, if you do have a clause in your contract which covers adjudication or expert determination, it makes it very easy because it will tell you exactly what procedure you have to follow, including the privacy measures, that you have to sign an agreement, that the parties are going to reach a full and final binding decision that will be respected when the adjudicator or the expert makes that decision. And that's the bit that you will then argue about if you have to go in front of a judge for enforcement purposes. So we don't have the luxury or the benefit of an actual set of adjudication procedures as yet in the Middle East, but there's no doubt that that progress is afoot to try and bring that to the fore. But the privacy issue really shouldn't be a big issue. It's nothing that can't be drafted away. If you don't have an adjudication or expert determination provision as part of your stage dispute resolution clause, then there's absolutely nothing during the amicable settlement stage to stop the parties agreeing to go through an adjudication process or an expert determination process if that's what they want to do. And again, you'll sign an agreement that says you've both agreed to commit to the process, etc., etc. So there are ways around facilitating active adjudication or active expert determination usage as ADR methods in the Qatar market. I think that covers everything for Seth, I hope.
So too. Yes, thank you. Thank you for all of that. I think we have another question for Ahmed. So the ED decision is final and binding. On what grounds then can the parties proceed to litigation? Can they proceed if they are simply not happy with the decision?
Yeah. I mean, that's what I explained. Moving on to the next step is time bar, basically. So if an engineer made his determination and that determination is not challenged or rejected by either party within certain time frame, then we will assume that both parties are happy with that. Okay, and the determination becomes binding to both parties. Okay, now if the determination is made and if you say a contractor, for example, is not happy with that, then he has the right, or it has the right within 14 days to just simply reject and issue an expression of let me say wish, I say, to refer the dispute to the next step, which is amicable settlement. So it's well regulated within the conditions.
Okay. We have one question for Tom. Any percentage of using new technologies such as blockchain and BIM in expert determination?
That's a tricky question with percentages. Just obviously, expert determination is clearly parties agreeing to appoint an expert on to help investigate and actually give an opinion or decision or determination, if you like, on a matter that is in dispute. So with expert determination, you expect the expert to use all tools that are available to investigate the facts, the issues that are being disputed, so that the determination can be full and complete. So in terms of percentage, again, depending on the case, if it's an engineering dispute, MEP, for example, you'd think the expert brought in to make the determination would actually use the tools like BIM modeling to actually understand if the issue is to do with clashes or defects in the design. So I'm not sure whether that answers your question, but with expert determination, you're allowed to use every tools that are there for you to actually make a determination on the facts or the disputes that the parties have who've approached you in to make that determination.
I think I can add another layer to help with what Tom's saying. When people approach me to appoint me as a legal expert to sit in expert determinations, very often they'll have a list of criteria of what they want their expert to be capable of doing. BIM features very heavily now in most of those expert requests, but very often we have to take the documentation and do an initial review and figure out what the actual dispute question really is before we go back to them. But very often, if there is a very clear, definitive, this should be handled by an engineer, or this should be handled by a PM, or this should be handled by a QS, or handled by someone who can use BIM or other technology, then quite clearly the dispute isn't over a legal issue. It tends to be over a technical issue. So it's actually quite helpful when anyone in the market is reaching out for expert help or adjudicator help at the very early stages. Think about what you think you really need to answer the question that is in dispute between the parties. Because there is no point you appointing a lawyer if your question is about the BOQ. There's no point you appointing someone like Tom to do a delay analysis when actually the question sits around the interpretation of, for example, the extension of time clause in the contract. So sometimes we find that expert requests, Tom, I don't know if you get this, but we sometimes get requests coming in and it's like it's gone out to kind of 10 people, but no one's really thought about what the dispute actually is. They just think they need an expert. So we're actually very lucky across the Middle East region, particularly in Qatar, and we have a wealth of really good legal and technical experts, private sector and public sector. And people will always be very honest with you when they respond, and they will say, I don't think I'm the right expert for you because what you actually need is A, B, and C. So do think about that you can ask those questions. It's at the end of the day, you're going to appoint someone to do this. You're going to, between the parties, you're going to pay them some fees. You want value back from what you're paying. and you want a good decision so that you then don't end up in litigation or arbitration. So don't be afraid to ask those types of capability questions when you come looking for experts, is what I would say.
Thank you, Paula, for that. We have reached the time for our webinar this afternoon. I know there are some questions that have still not been answered, or a section of certain questions, like Abdul has just pointed out to me, concerning the attire arbitration clause in the PWA contracts, and how that may cast doubt on the validity of the arbitration agreement. I don't know if you would like to continue for another 2-3 minutes, or if you would like to maybe address, these questions at some other point.
I'm happy to stay
Ahmed?
on for a little bit longer. I'm okay to stay for a while if no one else is.
Okay.
Well, it's a great time for me, to be honest, and I have to go.
Okay. So then maybe we should stick with our timeline. I want to thank you, all our speakers this afternoon, Paula, Ahmed, and Tom. Thank you very much for all the insights you have provided this afternoon from your respective areas of expertise. And we would also like to thank you, of course, Ashghal, for always supporting us. Thank you very much to everybody. Have a nice afternoon.
Thank you,
Thanks,
Katrina.
Katarina.
Thank you.
Bye,
Thank you,
everyone.
Paula. Thank you, Ahmed. Thanks. Bye.
Bye.